providers, staff and educators from family daycare services across Australia. My name is Nikki Spalding and I'm representing the Family Daycare Services Education and Support Project. This project is funded by the Australian Government, Department of Education and Training and managed by New South Wales Family Daycare Association. The project has included to date research, surveys, sector consultation, peak body collaboration, publications, information sessions, a website, resources, service support, newsletters and tools, as well as webinars such as today. A copy of the brochure relating to checking compliance for family daycare services is available on the Education and Support Project website. Due to the number of participants involved in the webinar today, we will not be able to take individual questions. Checking compliance for family daycare services. Approved family daycare services administer childcare fee assistance on behalf of families under Family Assistance Law. The Department of Education and Training has a childcare payments compliance program to ensure compliance with Family Assistance Law in family daycare services across Australia. The Department values the important role family daycare plays in delivering professional early childhood education and care for children and the dedication of family daycare educators towards their chosen career. The Childcare Payments Compliance Program is focused on protecting the integrity of payments made by the Australian Government to support families accessing quality childcare and promote compliant behaviour with Family Assistance Law by approved childcare services. This is achieved through three main elements of prevention, including education, detection and deterrence. On Thursday, the 17th of December 2015, there was a media release from the Senator, the Honourable Simon Birmingham, Minister for Education and Training. It read as follows: The Turnbull Government has taken unprecedented action to address flouting of government payments for childcare, with stronger compliance measures stopping $283 million of taxpayer money going into the hands of shonky family daycare providers. Minister for Education and Training, Senator Simon Birmingham, said the government's tough stance on childcare compliance means a more fair and equitable childcare system for Australian families, while better protecting those trusted centres that do the right thing day in, day out. Minister Birmingham said the government was taking a much tougher approach to enforcement of standards than had previously been the case, with sanctions and penalties imposed on over 50 services, recovering around $15.1 million in incorrect childcare payments. The webinar provides a general guide to some of the legal obligations of family daycare services approved for the purposes of Family Assistance Law. It is not a complete description of your legal obligations and does not cover all of the legal obligations of approved services. This webinar is built on publicly available information provided by the Department of Education and Training, and it is not New South Wales Family Daycare's interpretation of compliance. Once again, you will not be able to ask questions throughout this webinar session. We would instead direct you to the Department of Education and Training website for further information, or the Family Daycare Services Education and Support Project website, where you can download the Checking Compliance for Family Daycare Services brochure. On future slides, we will also share the appropriate email address and phone number for you to use if you believe you have information pertaining to non-compliance or fraudulent activities in a family daycare service or by a family daycare educator. You can provide this information anonymously. You must be aware of and should consult the relevant legislation for full details of your legal obligations. You may also wish to seek independent legal advice about your obligations. The information on the Childcare Payments Compliance Program is available on the Department of Education and Training website, www.education.gov.au. Compliance checking. The Department of Education and Training has a broad-ranging childcare payments compliance program to encourage, enforce and strengthen compliance with family assistance law in the childcare sector. The Childcare and Early Learning Compliance Framework focuses on establishing and maintaining a consistent approach to compliance activities for childcare providers across the childcare and early learning sector, giving substantial amounts of taxpayer money being paid to childcare providers. The Department's Childcare Payments Compliance Program seeks to protect the integrity of childcare fee assistance payments made by the Australian Government to support families accessing quality childcare services. The Department's Childcare Payments Compliance Program also seeks to promote behaviour by approved childcare services which is compliant with family assistance law. The Childcare and Early Learning Compliance Framework is based on high-level principles that the Department will adopt in developing specific compliance approaches and activities associated with ensuring the integrity of childcare and early learning programs and childcare fee assistance payments. Childcare providers have a responsibility to meet the terms and conditions set out in their funding agreements and contracts and or the requirements of the law in order to receive childcare fee assistance payments. The Department's Childcare Payments Compliance Program also, in relation to compliance checking, seeks to protect the integrity and reputation of the family daycare sector. The penalties resulting from non-compliance can be severe. Consequences of non-compliance. Family daycare is recognised as delivering quality professional education and care for children across the country. The aim of the compliance program is to provide assurance and confidence that the government's investment in quality childcare and early childhood education is being spent fairly, equitably and for its intended purposes. The compliance program ensures public funds are spent properly and accountably and not to maximise profits for the family care sector with no benefit to the education of children. Consequences of non-compliance. Family daycare services are responsible for the accuracy of claims made by educators. Childcare benefit approved for childcare services may be subject to penalties if they do not comply with conditions for continued childcare benefit approval. Penalties include suspension and cancellation of the service's childcare benefit approval, which may lead to recoveries of childcare fee assistance through legal proceedings. Infringement notices, which are monetary penalties issued for failure to comply with certain obligations under family assistance law. There could also be civil penalties, which are monetary penalties determined by the courts that do not involve criminal liability. They are issued to a service for failure to comply with certain obligations under family assistance law. Criminal investigation with significant penalties including fines and or imprisonment, which could also affect immigration status if that is applicable. Continuing with consequences of non-compliance, the Department may also write directly to families to inform them of the effect of their childcare fee assistance entitlement if their service is suspended or cancelled. Publicise information regarding sanctions, suspension or cancellation of a service for non-compliance with the conditions for continued childcare benefit approval. The following slides will provide case studies as examples of the consequences of non-compliance. Consequence case study number 1, charging more than the usual fee. A family daycare service was investigated for breaching its obligations to charge no more than the usual fee for jobs, education and training childcare fee assistance. The consequences. Compliance investigators found evidence the service had increased its fees once parents became eligible for JET CCFA. The service was given 22 infringement notices relating to a sample of 9 children over a 1-month period and fined over $550,000. Case study number 2, exceeding educator limits as per regulated ratio. A family daycare service employed more educators than permitted under its state regulatory authority service approval. Conditions of continued approval were imposed. The family daycare service continued to exceed its educator limits and failed to employ the appropriate ratio coordinators. The service failed to have adequate governance processes in place, and its failure to adequately monitor educators posed an unacceptable risk to the safety of the children. Consequences: the department cancelled the service's childcare benefit approval. Case study 3, submission of false claims. When a family daycare service submitted false claims, the case was referred to the Australian Federal Police. Several people were charged with a range of serious fraud offences. Consequences: the people were convicted of the offences, fined and given jail sentences. One individual was not an Australian citizen, and as they had broken the conditions of their visa, they were deported to the country of their origin. Case study 4, incorrect reporting, failure to submit in specified time frame. A family daycare service was investigated for breaching its obligation to submit attendance reports via childcare management system, no later than the end of the second week immediately following the week in which the attendance occurred. Attendance reports trigger calculation of childcare fee assistance payments. Failure to submit the reports in the specified time frame led to incorrect calculation of a family's entitlement. The consequences: debts were raised directly with the family by Centrelink. Investigators found evidence that the service submitted late attendance reports which incurred 8 infringement notices relating to a sample of 9 children over a 3-month period, and a fine of $90,000 was imposed. Case study 5, individual and community's reputation. An educator found guilty of defrauding the government by incorrectly claiming childcare fee assistance lost their job. As the educator had a criminal record, they were no longer a suitable person to work in the childcare sector. As their English language and skill sets were also limited, they found it difficult to find other work. The consequences: with a decreased income, the family struggled. The educators' community, aware of the fraud case, shunned them as they believed they had brought disrepute to the community and its members. Case study 6, CCB approval suspension. A childcare services childcare benefit approval was suspended for 2 months after the provider approval had been suspended by the relevant regulatory authority for not meeting obligations under the national law. The consequences: the service could no longer receive childcare benefit, and parents were forced to pay full fees as they did not receive childcare rebate for that period also. Parents decided the service was unreliable and removed their children. The service became unsustainable and closed. The Department of Education and Training has several ways to ensure compliance with family assistance law in family daycare services. The following slides will explain these measures and also provide case studies as examples of compliance checking. Tipoffs. The Department has a dedicated email address and telephone line for people who believe they have information about non-compliant or fraudulent activities by a family daycare service or educators. You can provide this information anonymously. The tip-offs are investigated by the department. The email address is tipoffline@education.gov.au. The calls can be made to 1800 664 231. Case Study 1 in relation to tip-offs, failure to provide quarterly statements. A parent contacted the department through the tip-off line because their service repeatedly refused to provide them with quarterly statements as they were obliged to do. The parent suspected the service was claiming for more care than was actually provided. Consequences. The department reviewed all attendance data submitted by the operator and found other similar cases. An infringement notice of $40,000 was issued. As there was an accumulated history of non-compliance, the operator was deemed unsuitable to operate a service and childcare benefit approval was cancelled. The service subsequently closed. Case Study 2. Receive or provide free childcare. A refugee with work rights in Australia was approached soon after arriving. They were told they could make a lot of money providing family daycare. However, the activities which the other person described were illegal, and the newly arrived individual would have unwittingly been drawn into fraudulent activity. The newly arrived individual had read the brochures, translated into their home language, urging people to be aware and contact the department. The consequences. The newly arrived individual contacted the department with details of the person who approached them. The matter was passed on to the Australian Federal Police. Random sample parent checks. Families are randomly selected to confirm that the childcare received matches the childcare data submitted by the family daycare service. The department also takes the opportunity to educate families on both their responsibilities and their service's obligations to ensure childcare fee assistance is administered correctly. In the first instance, letters are sent to the families to notify them that the department will be contacting them to verify their care usage. These checks are conducted nationally across all childcare service types and do not imply that the department has any concerns about the selected individual's care arrangements or their selected childcare service. Case study in relation to random sample parent check, incorrect reporting. A parent was contacted by the department and asked how much time their children spent in their particular family daycare service. The parent cared for their children full-time at home. However, a family friend had suggested they become an educator at the service where they worked and had assisted them to complete the paperwork. Although the parent decided not to be an educator, the information provided was submitted as data by the service, showing the family had used care. The service had claimed childcare benefit and childcare rebate. The consequences. The family daycare service was investigated and found to have falsely submitted data. Other non-compliance was detected. The case against the educator was referred to the Australian Federal Police. Targeted investigations. The department will conduct targeted compliance investigations on family daycare services identified as being at high risk of non-compliance using sophisticated data analytics. Compliance officers undertake surveillance and spot checks, sometimes accompanied by the representatives of the Australian Federal Police, the Department of Human Services and state and territory regulatory authorities. These investigations can lead to suspension and or cancellation of approvals, which in turn may lead to recoveries of childcare fee assistance payment through legal proceedings. Targeted compliance investigation case study. Check on care in an educator's home. A childcare compliance officer and a representative of the regulatory authority visited a family daycare educator's home together. The investigator ascertained that there were no children at the educator's home, but the educator was claiming for childcare they were not providing. The consequence: the information was passed on to the Australian Federal Police for investigation. While childcare compliance investigators may not enter an educator's home alone, a representative of the state regulatory authority is able to do so. Targeted call campaigns. Targeted call campaigns are where the department contacts families registered at a family daycare service identified as being at high risk of non-compliance. Families are asked to confirm their childcare arrangements, which are then compared to childcare data submitted by the approved family daycare service. Data matching. The department shares data to identify non-compliance and fraud across agencies, with agencies including the Australian Federal Police, the Australian Taxation Office, the Department of Human Services and Department of Immigration and Border Protection. This ensures approved family daycare services are correctly applying the rules under all relevant laws and assists to identify fraud across agencies. The case study in relation to data matching, claiming for hours of providing family daycare while overseas. A family daycare educator, while overseas visiting family, continued to claim for providing childcare. The Department of Immigration shared data with other agencies which showed when the educator departed and re-entered Australia. This evidence, along with childcare management system database, confirmed care had been claimed for, and this information was given to the Australian Federal Police. The consequences: the service, which was responsible for ensuring submitting data is correct, was sanctioned and a childcare benefit approval was cancelled. The service was closed down. The educator was investigated and convicted of fraud. Case study 2, non-declaration of income. An individual earning a regular income as a family daycare educator with an approved service did not declare their income to the Australian Taxation Office. The educator also claimed income support for being unemployed. They were unaware that the Australian Taxation Office, the Department of Human Services and the Department of Education and Training work closely together on non-compliance matters and that their IT systems are linked. The consequences: the information was passed to the Australian Federal Police and the educator was prosecuted for tax fraud and Centrelink fraud, which incurred a large Centrelink debt. They were no longer a suitable person to be an educator as they had a criminal record. Work with key government agencies. The department works closely with key Australian government agencies such as the Australian Federal Police, the Australian Taxation Office, the Department of Human Services, the Department of Immigration and Border Protection, and state and territory regulatory authorities to ensure approved childcare services are compliant with the rules under all relevant laws. Respective compliance powers are used to maximise effect against services identified as being at high risk of non-compliance. The case study in relation to work with government agencies. Incorrect reporting of SCCB. A family daycare service was investigated for breaching its obligation to ensure it did not self-approve more than the permitted limit of special childcare benefit in a reporting period. The consequence: investigations found the service had breached the limit as the department calculated an overpayment of $120,000, which was raised as a debt against the service and recovered from future payments. The service was restricted from self-approval of any special childcare benefit for a 12-month period. For more information on the Childcare Payments Compliance Program, you can go to www.education.gov.au/Childcare Payments Compliance Program. To access more family daycare information resources, you can go to www.education.gov.au/family daycare. The Compliance for Family Daycare Services brochure is available to download online through the Family Daycare Services Support and Education website or by sending an email to information@fdcsupport.org.au. Tipoffs. If you believe you have information about non-compliance or fraudulent activities by a family daycare service or by an educator, please email tipoffline@education.gov.au, or otherwise you can call the 1800 number 1800 664 231. Thank you for taking part in this webinar presentation today.